Good morning, everyone, and welcome to the Beasley Allen webinar series. On today's program, you'll discover what's new with Camp Lejeune water contamination claims. I'm David Byrne, and it's my pleasure to introduce our panel of speakers for this important litigation topic. Today, Beasley Allen attorneys Julia Merritt, LaMacchia, Matt Pettit, and Elizabeth Weyerman will update you on the Camp Lejeune Justice Act claim procedures. They'll recap the Act's benefits and eligibility requirements, and they'll address the things that you should look for when screening your client cases. Before I turn the program over to our speakers, and while we're waiting on the last of our registrants to join us, let's go over a few important housekeeping notes. First, today's webinar has been approved by the Alabama and Georgia State Bars for 1 hour of CLE credit. In order to receive that full credit, you've got to stay on for the duration of the program. A link to today's presentation was included in the Zoom confirmation email you should have received when you registered with us. But by the end of this week, you'll get another email with a certificate of attendance and an updated presentation and video link. You can email that completed evaluation form to webinars@beasleyallen.com. This webinar is being recorded. And for those Alabama and Georgia attorneys who are participating by phone today, I ask that you'd email us your name, your phone number, and your state bar ID number. You can send that to webinars@beasleyallen.com. For those of you practicing in other states besides Alabama and Georgia, we'll send you a certificate of attendance that you can present to your own state bar for credit. Also, be sure to check out the events page of our website, beasleyallen.com/events, as we'll be adding more webinars throughout 2023. Now, our next webinar, The Plain Truth, Finding Liability in Aviation Crashes, is scheduled for next Wednesday. That's next Wednesday, December 7th at 11 a.m. Central, noon Eastern. Finally, if you have questions during today's webinar, I want to encourage you all to use the question and answer feature located at the bottom of your screen. Our panel is going to set aside time at the end of today's program to try and tackle all of the questions submitted by our viewers. So with that, Julia, Leslie, Matt, Tricia, and Elizabeth, the floor is yours.
Thanks. I'm going to be starting today giving you a brief overview of the bill itself and then where we stand in the litigation currently. So Camp Lejeune Justice Act is part of a larger bill honoring our PACT Act, and that bill was signed by the President on August 10th, 2022. And this is an important date because it's going to set the outside scope of when you're able to file both an administrative claim and a follow-up civil litigation. And we'll get into that a little bit more in a bit. You can find the full text of the bill at this link, and the section starts with section 804. Next slide, please. So this is a very unique statute. There's no real comparison for it. It was created specifically to address the wrongs and, quite frankly, the failings of the MDL that came before this act. And so because of that, there are some important aspects that makes it different than most civil litigations going on currently. For starters, this bill covers any individual who was at Camp Lejeune who was exposed to water for more than 30 days. I say individual because individual can cover both a serviceman, a family member of a serviceman living on base, and also children who were exposed to water in utero while the mother was on the base. It also extends to civilian contractors. So about the 30 days, it does not have to be consecutive days. It just has to be 30 days cumulative. Another unique aspect is that the exclusive jurisdiction is in the Eastern District of North Carolina. This is prescribed by statute, and this is not a multi-district litigation. So the JPML rules, the MDL rules, and none of those are at play. The burden of proof is lower for this federal action than the traditional civil litigation, which requires the preponderance of evidence. And that sets that it has to be greater than 50%. Now, for this statute, the burden of proof is equipoise, which means as likely as not. And so that standard allows for proof that is at least 50%. And equipoise is going to be a term that you kind of hear frequently, and we'll get more into that later on in this presentation. But another unique aspect, or go back. Another unique aspect is that the Camp Lejeune Justice Act imposes its own statute of limitations and statute of repose that supersedes North Carolina's standard statute of limitations and statute of repose. And this extends to wrongful death cases as well. So it is unique in the fact that a wrongful death case where an individual passed away decades ago is still a viable claim under this statute. The statute allows for a claim to be filed within 2 years of August 10th, 2022, and then an additional 6 months to file a civil claim, whichever one is later. So at bare minimum, you need to have your administrative claim filed by August 10th, 2024, and then a civil claim will file within 6 months. A prerequisite to filing a civil suit is that you have to go through the administrative claims process. And generally speaking, this is important. It's important to know that this is not through the Federal Torts Claims Act. It is wholly separate and apart from that. The Camp Lejeune Justice Act does borrow the notice language from the FTCA that is required to give notice to the government, but it is wholly separate from the Federal Torts Claim Act in and of itself. And so because of that, the government has more limited defenses than what is traditionally allowed. I've already mentioned the adjusted statute of limitation and statute of repose, but the statute removes sovereign immunity as a defense for the government, and it also removes the fairness doctrine from the government's arsenal. I believe most people are well familiar with sovereign immunity, but the fairness doctrine is a defense that prevents members of the armed forces who are injured while on active duty from successfully suing the federal government under the Federal Torts Claims Act. And so since we are using a different vehicle to travel under, that's why that fairness doctrine is going to be inapplicable. Now, a big part of the questions that we get every day is the language that relates to offsets and VA disability benefits. We'll go into a little bit more detail of that later on, but what's important to know is that as the statute is written, any potential award or settlement is not meant to disrupt VA benefits. There is language that says any kind of monetary amount that an individual is receiving from their VA benefits will just be offset from any potential settlement. And so this will act more like subrogation to Medicare. Now that only really relates if the VA disability injury is the same injury that you were claiming for your Camp Lejeune. If they are separate injuries, because some of these individuals will have benefits for various different injuries, then if it's an unrelated injury, then you won't have to be concerned about offsets. Now, another aspect of this bill that is unique is that the funding is from the judgment fund. And the judgment fund is a permanent, indefinite appropriation that is available to pay monetary awards against the US government that are judicially or administratively ordered. So this is good in this case because any kind of future funding will not have to be approved through votes. And most importantly, it's not going to be a race to the bottom. These funds will be available. It's not going to be like some of those other litigations where you need to get first in line and then go through the process. But one aspect that is different than traditional civil litigation is that only punitive damages are allowed in this suit. I'm sorry, only compensatory damages are allowed. Punitives are not allowed under this. And let's go to the next slide. So that was kind of a history of how we got here. And now I'm going to talk about what's kind of going on currently. So we get a lot of questions every day about the status of the administrative claims process. Have we heard anything back from the claims that we have submitted? Have we gotten any substantive offers, or what's just going on in general? And in our experience, the only kind of feedback that we're getting from the administrative claims process is just confirmation that the claims are being submitted. At this point, we haven't received any offers. We have not received any follow-up. And so that's kind of where that aspect is. Now, there are some cases that are already filed in the Eastern District of North Carolina, and we kind of term these as legacy cases. These cases are individuals who filed for VA or filed a claim under the Federal Tort Claims Act prior to the passage of Camp Lejeune Justice Act, and they were denied. And so they are using those denials to try to jumpstart the process and file their civil claims. Now, what the issue is these legacy cases, the judge, the US government, and the plaintiffs for those cases filed a joint motion for consolidation, and that was denied. And it was denied on the grounds that there was disagreement between the US government and those plaintiffs. The plaintiffs are saying that they have complied with the administrative claims aspect, and the government is saying that you haven't because those were prior to the passage of the Camp Lejeune Act. So the motion to consolidate has been put on hold until that issue is resolved. And as of today, that has been fully briefed, but I believe there is still not an order out regarding the status of those cases. One other important thing to mention about litigation in general is that North Carolina is a very protective state, and they limit, they are routinely enforcing their ethical rules and their local rules. If you just take a quick review of the dockets, you'll see that they are strictly enforcing everything. And so our advice to anyone looking to get into this litigation is for you to be familiar and comfortable with the local rules and the ethical rules, because ultimately, since this is the exclusive venue, if you want to stay on the judge's good side, because this is the only place these cases can be litigated. And next, there are currently a lot of rumors going around, since this is kind of unprecedented and there's no similar statute. Just real quickly, a lot of questions we get is about estates. What's going to happen with estates? And so we have talked with some of the clerks and attorneys locally, and they have told us that they're being told that they will be able to open an estate in Onslow County, and that's per North Carolina Statute 28A-3-1, subsection 2. And the most important thing about that is that if an individual was died outside the state, they're able to open an estate and probate anything within Onslow County, because the lawsuit itself is going to be seen as an asset. And so language in that statute allows for a probate to be opened if there's an asset in that county. There is another rumor that's going around right now. There is Senator Sullivan from Alaska is aggressively working to restrict the attorney's fees in Camp Lejeune. At this moment, there is no caps on attorney's fees. It does not take the 20 or 25% cap by the Federal Tort Claims Act. There's no restriction. Now, Senator Sullivan is aggressively moving to put a cap on these fees. And from what we've heard, he's suggesting a 2% cap for administrative claims, and anything that goes beyond that would be 10%. He intends to raise that issue to the Senate floor soon, and the expectations are that he won't be successful, but it most likely will open a door to a future conversation about potentially reducing attorney's fees. And just as an aside, Beasley Allen's practice right now is that we are opening all estates for any wrongful death case before we file an administrative claim. And that is just to make sure that everything is in line like it's supposed to be. We found that through this military people, there are individuals that multiples might claim for the same individual. So we're doing this just to make sure that everything is as it should be. And that is all I'll be talking about today. And we'll switch it over to Julia, to talk about Camp Lejeune's history.
Great. Thank you, Matt. And thank you everyone for joining us and spending your lunch hour with us. And we've had several questions come in on the Q&A. We will reserve those questions to the end, but I encourage each of you to ask questions. And at the end of this presentation, you'll see our email addresses. That's what we're here for. Send us questions, send us emails, and we will do our best to get back to you as soon as we can. So Camp Lejeune was constructed in 1941 and opened in 1942. It is a U.S. Marine Corps base located in Jacksonville, North Carolina. As you know, the requisite dates of exposure are between August 1, 1953 and December 31, 1987. And the claims are available for people who were present at Camp Lejeune for 30 days or more. It does not have to be consecutive days. And it does not have to be a Marine. It can be a Marine, a family member, a civilian, a veteran. We have had one case, a claimant contact us who was a Boy Scout as a kid and camped at Camp Lejeune during the summers. And so, you know, if we can prove his exposure, then that would count as well. So what kind of chemicals are we talking about? These are volatile organic compounds, VOCs. What is a VOC? It is a compound that has a high vapor pressure and a low water solubility. So they're human-made chemicals, typically, not always. They're used in the manufacture and production of paints, pharmaceuticals, refrigerants. They are industrial solvents. They are petroleum fuels, hydraulic fuels, paint thinners. They're also used as dry cleaning agents, and they are common groundwater contaminants. And I'm going to show you a lot more about this as we continue talking. Can go to the next slide, please. So there are three water systems at issue in this litigation. The first is Hadnot Point. The second is Tarawa Terrace, and the third is Holcomb Boulevard. So Hadnot Point was the first that was constructed, and you can see this on the map in the middle, like toward the bottom right, it's a dark gray color. Hadnot Point has its own drinking water system. It provided drinking water to the main portion of the base at Camp Lejeune, which was most barracks and workplaces, and that was starting in 1941. The second one at issue is Tarawa Terrace, and that was in 1952, and you can see that on the map at the top is kind of the lightest color up at the north. And the third is Holcomb Boulevard. That is the light gray portion along the center of your screen. That was established in 1972. Before that drinking water system was established, Holcomb Boulevard service area received drinking water from the Hadnot Point water treatment plant, excuse me. And these water systems were contaminated by the volatile organic compounds that I mentioned before. What went wrong? Well, there was a dry cleaning facility that dumped water into New River, and it contaminated the water supply. It was a series of unrelated events that happened over a period of over 30 years. One was that dry cleaning spill I mentioned. There were underground storage tanks holding diesel fuel that was leaching into the water system. And, if you think about it, it makes sense because we're at a military base, and, they're using a lot of heavy equipment, and we're holding a lot of different types of fuels and solvents. So when were these water systems contaminated? We first learned, samples were first taken in 1982 at Hadnot Point. And I'll tell you that the maximum contaminant level for one volatile organic compound, TCE, is 5 parts per billion, but samples were found as high as 1,400 parts per billion. And here at Beasley Allen and the Toxic Torts Litigation Practice Group, we do a lot of toxic water contamination litigation. And I can tell you that that's an astronomically high contamination level and causes a lot of illnesses and diseases. So it's really sad for people who were contaminated with this water. Another contaminant is PCE. The maximum contaminant level is 5 parts per billion. That's what's allowed. Samples were found at 100 parts per billion. Vinyl chloride and benzene were also detected at had not point. So what we know from these reports is that the government knew in 1982 that there was contamination, but did not shut down some of the wells until 1985. Historical construction modeling of the drinking water was done, and it shows that these chemicals were likely present since the 1950s. So that's where the exposure period in the Camp Lejeune Justice Act came from. It is estimated that had not point water system was contaminated as early as 1953. So now looking at Tarawa Terrace, that plant provided drinking water to the Tarawa Terrace housing area at the base, as I showed you earlier, in that kind of cream colored area at the top. That area was contaminated beginning in 1957. PCE, which I told you earlier, the maximum contaminant level is 5. It measured as high as 215 parts per billion. So what do we need to prove, and how do we prove it for these cases? Let's go to the next slide. So as I told you before, there were 3 areas for residents that were exposed: Had Not Point, Tarawa Terrace, Holcomb Boulevard. And we have to show that an individual came into contact with the contaminated water, bathing, drinking, cooking. And if you think about it, these Marines who were training at this facility were in active training. They're doing really hard workouts and exercises outside in North Carolina heat in the summer. And they were likely to drink 6 liters per day on training days. So first, we have to show that they were contaminated, came into contact, and then they had to be there for at least 30 days. Okay, we can move on to the next slide. So as you know, there are 4 different chemicals involved. It's TCE, PCE, benzene, and vinyl chloride. This is where the complicating part comes in, and this is where good lawyering and good investigation and expert work comes in. I showed you on that map that there are 3 different water treatment facilities that were contaminated, and now we have 4 different chemicals. And I can tell you from our intake experience, we have hundreds of different illnesses. How do we go about linking our client's location, the chemical, the year, and the illness? You've really got to work with a map. You've got to figure out what year were they present, where were they, get creative with your exposure evidence, ask where they worked, did they go to any classes on base, where were they getting their food, figure out, did they go swimming in New River, where were they drinking their water, where were they filling up their water fountain, where their drinking containers from. So figure out exactly all of the different locations where they were exposed. And then you have to figure out which diseases they have. And I can take you to the next slide and start talking about that. So this is where the ATSDR comes in. What is the ATSDR? It is the Agency for Toxic Substances and Disease Registry. It assesses the presence of health hazards at specific Superfund sites like Camp Lejeune. Camp Lejeune is a Superfund site. And what is this report? So it's got a pretty lengthy name. It's the Assessment of the Evidence for the Drinking Water Contaminants at Camp Lejeune and Specific Cancers and Other Diseases. This specific report was updated on January 13th, 2017, and I've provided the link for you. This report is what is bringing it all together in this litigation. It is the guidepost, and it's what you need to turn to when you first start. So you can please move on to the next screen. So this report compiles epidemiological studies to determine if people at Camp Lejeune were at an increased risk for certain health issues as a result of exposure to water contaminated with the volatile organic compounds that we've already talked about. So the ATSDR did not conduct its own studies. It reviewed scientific literature on the contaminants and the health effects of these chemicals and compiled this report. It summarizes the evidence for 16 different diseases, and there has to be at least some causal connection with the volatile organic compounds that contaminated the drinking water. So as you can see, this report, it's really a great report. I encourage you to read it cover to cover. It's 150 some odd pages, and I have it with me pretty much at all times, and it's my go-to. It gives you the history, and it gives you the epidemiological reports and studies. So we can move on to the next slide, please. So these are the 16 diseases or injuries that the ATSDR report has compiled. Now, the Camp Lejeune Justice Act requires an equipoise burden of proof, and Matt discussed that earlier. So equipoise is a clinical research term used in epidemiology, and it basically means that there is an assumption that there's not a better reason present for this illness. So that is what this ATSDR report analyzes, is whether there's a causal connection between one of the volatile organic compounds and one of the illnesses or diseases at issue. So you can read this list, and I will tell you, just because this is on this list, it doesn't mean that there's equipoise causation. For example, esophageal cancer does not have equipoise causation for any of the 4 volatile organic compounds, but it was studied and analyzed, and it is in the report. So the report lays out different, what chemical and what level of causation and what disease is linked. So I'll give you an example on the next slide. So there are 3 levels of causation laid out in the ATSDR report. The highest is sufficient. That means evidence is sufficient to conclude that a causal relationship exists. So that means if you have a client who was exposed to, I'm going to go through these 4 VOCs at the top and talk about each illness. If you have a client who is exposed to TCE and he or she has kidney cancer, then you have sufficient causation. If you have a client who has non-Hodgkin's lymphoma and they were exposed to benzene, you have sufficient causation. And this is where you have to go back to that map, figure out when the spill occurred, figure out where the testing occurred, look at the ATSDR report, figure out where your client was drinking their water and bathing and cooking, figure out what illness they have and link it up. So that is going to be a presumptive illness. These are some of the presumptive illnesses that there is sufficient causation. So next slide, please. The next level of causation is equipoise and above. And as Matt discussed earlier, that is the minimum level of causation required under the Camp Lejeune Justice Act. That is lower than a typical standard of proof in civil litigation. And it's a really great statute for plaintiffs because it is a lower level of proof that's needed. And again, it's that assumption that there's not a better reason present for this illness to have occurred. So I've got the top 4 volatile organic compounds listed again. TCE, if your client was exposed to TCE and he has multiple myeloma, you have equipoise causation, and that's a presumptive illness. You do not need to hire an epidemiologist to prove your case. The ATSDR report is sufficient. So we can move on to the next one. So this is below equipoise. These are different illnesses that were studied and sufficient causation was not found. So, you know, as I discussed before, esophageal cancer, PCE has not shown that there's a causal relationship. Now, does that mean we're rejecting these cases? No, it means that maybe the client was exposed to a different chemical. So you have to really do your work here. You can rely on the ATSDR to a certain extent, but you know, it's not enough. You're going to need to hire your epidemiologists. You're going to have to do some water studies and really dig in, and you have your work cut out for you on these cases. So next slide. And now Elizabeth is going to talk to us about what intake is really like. Thanks for your time.
Thank you, Julia. So the Navy is estimating that there are up to 1 million people that were exposed to contaminated water at Camp Lejeune. This includes not only members of the military, but like Matt was talking about, also civilians, whether they worked at Camp Lejeune or were children, even children in utero, spouses, or other family members of those stationed at Camp Lejeune. When you start your intake process, make sure to have a very defined plan. We have covered some of the criteria that's required. You need to teach staff how to handle your calls by asking clients where they lived. Julia just talked about the 3 locations, Hadnot, Tarawa, and Holcomb, and make sure your staff knows the exact exposure dates from August 1st, 1953 to December 31st, 1987. You need to train your staff on the actual ATSDR injuries and that 30 days exposure is required. It's really important that during this process, you understand and you train your staff how to handle these types of intake calls. Also, make sure that you and your staff understand what injuries are presumptive and what are considered other injuries. The ATSDR listed those 16 presumptive injuries that they studied, but of course, there are other injuries that these 1 million people have and that you'll come across in your intake process. Your firm will need to decide how you're tiering each injury. Our firm is considering the presumptive injuries as tier 1. Like Julia said, these have already been proven by the ATSDR report. Now, if you have other injuries, just be aware that you are going to have to prove them up as usual using an epidemiologist and other experts. The other injuries will be any other injuries that you come across or learn about through your conversations with claimants or with your hired experts. It's important that you explain the process to your claimants on the front end instead of as the intake process progresses, especially the referral process. If your firm is not personally going to handle these cases, you have got to talk to your client about the referral process. Let the claimants know that there is an administrative claims process, which we'll talk about next, but explain to your claimants that that is the next step after they sign all the documents that are needed, and that they will also need to file an authority to file document with the Navy. That authority to file allows us as lawyers to file an administrative claim on their behalf and then a civil lawsuit. So if you're a referral lawyer, you will not be signing the administrative claims form. So make sure that your claimants understand that as well, that the actual firm handling the claim will be filing the administrative claims form on their behalf. We do believe that the intake process will become more streamlined in the future as litigation develops. The Navy has talked to us about a potential portal that they are working on to create so that firms can upload documents instead of emailing them, etc. But it's very important that your staff understands the intake process right now as your firm is handling them. Now, in vetting these cases, make sure that your intake staff is asking the right questions. Let them know that the claimants will be signing a bunch of authorizations that they need to fill out. We're going to be gathering a lot of records during this process, from military providers to private providers to multiple medical providers. Many claimants will have multiple diagnoses, and we need to make sure that you confirm all of their diagnoses, not just one. Explain to claimants the types of records that you're going to be seeking and the authorizations that they will be signing. They'll be signing medical authorizations, the VA authorization, and a DD-214. The DD-214 will allow us to obtain their military service records. It's basically like an active duty resume. It's very important that when you're sending these authorizations, if it's a spouse, you do not want to send the spouse the DD-214 or the VA authorization if they were in the military. You need to be careful what claimants are receiving which authorizations. So here I also want to make the point that these are sensitive matters. Many claimants are very ill, most are elderly, many might need help filling out paperwork, some have suffered multiple miscarriages, and all have been waiting a very long time for these cases to come to fruition. So please, for you and your staff, remember that you need to be patient with these claimants and handle these cases delicately. That goes from the tone you use on calls, making sure your communication about the process is clear, and making sure that these claimants get the right paperwork. That also goes to say that we're constantly learning. I met one of our clients yesterday in person, and she lived at Tarawa Terrace, and let me know that we had been saying it incorrectly as tarawa terrace. So knowing that these clients have served in the military, learning the Marine lingo is very important and lets them know that we're handling their cases extremely seriously. Now let's talk a little bit more about building up your case. So here we need to get creative. Since we need to prove that each claimant was at Camp Lejeune for at least 30 days, ask them if they have photos of themselves at Camp Lejeune, if they have photos of the house or housing where they resided, if they have any school records, if they attended school there, if they have any old bills, anything like that. And of course, if the claimant is now deceased, we will ultimately have to get the parent or the spouse's records and make sure that we have the proper authority to get those. Now let's talk about the law firm registration. Leslie's about to tell you about the administrative claim process, but no matter how you decide to do the claims process, each firm needs to email in one law firm registration. So for the attorney contact information, that's going to be on the left side. This should be completed for each attorney that's expected to represent clients with these CLJA claims. Under the action field, you'll select add, and then the email notification email's purpose is to put a preferred firm-wide email address. You'll see that in the middle of this. The email type has a drop-down to allow you to select either no reply or replies allowed. If you select no reply, the email address is either not able to accept reply messages or it's not monitored for reply messages. If you select replies allowed, that means that the email address is able to accept reply messages. Now, the drop-down option for email preference allows your firm to indicate whether you want communications regarding individual claims to be sent to the firm e-notification email address only, just the individual attorney email addresses you've listed, or both. If the tortious claims unit, the TCU, has updates to the claims process and electronic filing procedures, these will be sent to both the firm email address and each individual attorney. If you list a legal technologist in the top right, TCU will attempt to contact them if they encounter any technical issues before they contact the attorneys. Once you've completed this form, which you can request by emailing the cl.claims@us.navy.mil, that's the email address listed in the top left, you'll save this as a PDF and email it to that same email address with the subject line completed registration form. If you have any updates to which attorneys will be handling these cases, you'll email this firm again, but you'll list only the firm's information and the new attorney information that needs to be modified, and select modify in the action field instead of add. Now Leslie is going to tell you about the administrative claim process.
Good afternoon, y'all. I think this is the fun part where we actually get to fill out the administrative claims form and send it into the Navy. So when doing so, the tortious claims unit has given us 3 options to file your administrative claim. You can either file it individually, you can send it in on CD-ROM, or you can send it in by CSV. They are, as Elizabeth had explained, they are exploring an electronic filing option like an online portal in the future, but that has not happened yet. Next slide. What I've done next is I've taken the sample claim form and I've broken into 2 parts here. I do have a form link for you in a subsequent slide, but let's go through this. The first box is who you are going to be submitting it to. The second box is a fillable box where you will include the name and address of the claimant and also the claimant's attorney. On box number 3, you will mark off what type of employment they had. Were they there as a military member or as a civilian? Their date of birth and the claimant's marital status. Number 6, box 6, is the dates in which they were at Camp Lejeune. If you specifically know the dates based on the DD-214 records that you are able to obtain or the client has provided to you, put those exact dates in. If they are estimated dates, my recommendation would be to put in 0101 and the year to 0101 and the ending year, and then check off the estimated box. The next part of the form that you will fill out is the basis of the claim. This is the status, the claimant's status at the time of their exposure at Camp Lejeune. There will be a drop down box. This person here has checked off that they were a member of the armed forces. It also gives you other options, whether they were a civilian employee, a civilian military dependent, or a worker. If you were working for a private company on the base, you will provide the name of the employer in the additional information box. If you were residing at Camp Lejeune, 8B allows you the opportunity to check off where you resided. If you worked at Had Not Point, you will check off yes or no. 8D is being able to select the nature of your injury. This is very critical here. You will have two options. You will either be able to check off personal injury caused by the water or wrongful death. If this example that I show you, it's marked off as personal injury, but if you check off wrongful death, if the cause of death was related to a presumptive injury per the ATSDR, you will check off wrongful death. If the cause of death was not related, but was diagnosed and maybe an underlying condition that was presumptive, you will check off PI, okay? So for example, if the death certificate says that the claimant died of cardiac arrest, but an underlying condition was, let's say, a leukemia, and it's presumptive, then you would check off a personal injury claim, okay? Next slide. Number 10, you will check off each injury or cause of death, which forms the basis of the claim. Number 11, if you are filing the claim on behalf of yourself, then you would skip to the next box. But if it is a wrongful death claim and you are the agent, the proper agent to fill out the administrative claim, then you will fill out this section. Now, you will have to prove that you are the authorized agent by providing evidence of such, and you will have to attach the evidence to the claim form. So some sort of evidence of authority, whether it be a court order, power of attorney, any kind of proof of qualification as to the executorship, or if you're the administrator, you have to provide that. And then for the amount of claim, what we've been doing at Beasley Allen is if it's a personal injury claim, we've been putting in $10 million. We do not want to undersell this claim whatsoever. $10 million, in our opinion, is reasonable that you would ask a jury for $10 million. It's the ceiling, okay? There's no punitive, so we've selected $10 million as a personal injury claim amount. For wrongful death, we have chosen $25 million for 12C. If you are familiar with the Federal Tort Claims Act, you understand that the Tortious Claims Unit has the authority to resolve any claim up to $500,000, but this is not the FTCA, so that's why we have chosen these amounts to be the claim numbers. And so if you go to the next slide. So as I said before, when filling out the administrative claim, you then have the option to file it individually. If you do so, you mail the completed form and any attachments to the address here, or you can email it as a PDF to the email address provided that was provided by Elizabeth earlier. You can provide signatures digitally or physically, but you will not be submitting any medical records and any other substantiating documents with the claim form. Any attachments, if you are filing it individually by email, any attachments will be rejected if they're over 20 megabytes. If you choose to, next slide, Elizabeth, please. If you choose to file the claims by CD-ROM, there's the instructions, the link there. You will burn a CD-ROM, create two folders, one with the claim forms and the other with the authorizations. You will make a cover letter to include the number of files that will be in each folder that are on the disk. And then you will mail the CD-ROM and the cover letter to the address there. Mailing it by CD-ROM, I know it seems kind of antiquated, but it does allow the tortious claims unit to use JavaScript and these types of files to import and export into its claims management system. Once you email, once you have either submitted a form by mail or by email or by CD-ROM, you will receive acknowledgement to the email address that you registered with the Navy. Next slide, please. All right, this is our preferred way to submit. Everything is through CSV, which is comma separated value. It allows you to file your claims in batches of up to 1,000, but the Navy will accept more or they'll accept less. Once you do submit by CSV, you'll receive an automatic email response back from the Navy saying, hey, we've received it. You will have to create a cover letter, which does have a certification. And if you can see on the side, it says that you certify as the attorney representing all the claimants below. And yes, you will have to list all of your claimants with your unique identifier number. So that certification continues that all supporting original forms and authorizations to file claims with original signatures have been verified and are accounted for and can be provided to the Department of the Navy upon demand. This means that you have original signatures on your authorizations, your authority to file, and anything else that has an original signature, that if the Navy said, do you have that, that you have that. Again, if there's any technological issues that you're having with creating your CSV or submitting your CSV, Jennifer Langley Carnes has been really helpful and responsive. So go ahead and do that and put CLJ IT issue in the subject line. Next slide. I haven't been able to look at some of the questions in the chat box, but some of the questions that I do receive from both attorneys, referral attorneys, and also claimants are, one, why can't I handle this myself? Well, it is actually a more complex issue than we really think. And also us attorneys right now, we're really in the know. So I like to tell the clients that it's not just submitting a claim form and expecting a response back from the Navy, right? We're going to eventually have to file a civil lawsuit. So I just recommend to the clients that, hey, let us do it. We're on top of everything. We're understanding the litigation as it progresses, and we'll eventually have to file a lawsuit on your behalf. Next question is, how much will I get? I don't know. I just can't answer that question. I mean, it's nothing that any of us can ever expect in any regard. So I don't know how much you will get. The timeline for the process, well, unlike any other mass torts where typically could last between 3 and 5 years, we're just not sure of this time frame yet. We do know that there's a 2-year filing period for the administrative claims, plus the 6-month window to file a civil lawsuit. So that's as much as I can tell them now for the actual timeline. This is not a class action. The injuries are different. The damage amounts are different. So I let them know that is not a class action. What if I was at Marine Corps Air Station New River? Unfortunately, no, because the ATSDR has found that it was not contaminated. The water there that was studied was not contaminated. That goes for Camp Johnson and Camp Geiger as well. This is the big question. What if I'm currently receiving VA disability benefits? I'm going to talk about this on another slide, but what I recommend is to do your own research as a lawyer, to do your own research on how to advise a client. There is nothing currently set in stone under the CLJA, but right now there is no harm whatsoever in preserving a claim for your client. If, however, your client is receiving 100% disability benefits, I would recommend not filing an administrative claim. If you can go to the next slide. I also get a lot of questions, these types of questions about how it'll affect if they file an administrative claim, or how it would affect their VA benefits from clients because they've received this newsletter from the VA. Again, I just tell them, weigh your options, talk to your lawyers. Eventually there is a There will be offsets. We just don't know that yet, what percentage offsets based on their VA rating. Eventually, they will fill out a form and we will be notified of what their VA disability rating is. It's just something, it's just not set out in stone right now. So you just truly, as this article suggests, you do have to weigh your options. Next slide. Here's some really great resources that we've found that give some great timelines about Camp Lejeune, the litigation, some great VA websites, and then to order military records, there is a portal. That is the website, the last one. If your clients want to be able to do it online, these are some really great resources. I know you guys are going to have access to a lot of the slides and the links, but if you have any questions about anything that's been presented, let us know and we'll get you hard copies. I would like to turn it over to David, hopefully to maybe help us answer any questions that have been asked.
Absolutely. Yeah, absolutely. And listen, on behalf of all our viewers, I want to thank Julia, Leslie, Matt, Tricia, and Elizabeth for really bringing us a very thoughtful and thorough presentation. And you're right, we have received a number of questions during your talk. And if you'll allow me, I'd like to present them to you and get a little bit of feedback from you. Some of these questions may have been covered, and if they were, panel, feel free to let me know and we'll move on to the next question. So let's start off with a question from James. James asked, are there scenarios when a claimant may have both a personal injury claim and a wrongful death claim?
I can answer that one. I would say no. Once the person passes away, then their wrongful death claim supersedes the personal injury claim. And that actually goes along with another question that I just answered personally. Someone said, what if I started out with a claimant with a personal injury, I submitted a claim form and they later died? We have had to amend a claim form, and you just have to email the email address that's previous, put claim amendment and in the subject line, and I would send an updated claim form changing it from personal injury to wrongful death.
All right, very good. Our next question comes from Robert, who asks, if an estate has already been opened in a state other than North Carolina, does a separate or ancillary estate also need to be opened in North Carolina?
I'll take this one. So we have gotten a lot of questions about the necessity of an ancillary estate being opened. We have talked with a couple of, this is just our own due diligence. We've talked with a couple of North Carolina specific estate attorneys, and they're equally puzzled by the ancillary estate requirement or rumor that's going around. And so we're operating on what we've been told, that an ancillary estate will not have to be opened. Now, if you have an estate that's already been opened in a previous state, you won't be able to open one in Onslow County. That is one of the caveats to that statute that I mentioned earlier. And so that's just going to be another thing where, as an attorney, you're going to have to weigh whether or not you want to open one in a separate state or open one in North Carolina.
All right, thanks, Matt. Our next question comes from Leslie, who asks, isn't it possible that an individual was exposed even if they did not live in one of the 3 locations mentioned, because water trucks were used to take water to training grounds?
I can answer that one. Absolutely. The 3 locations that I mentioned are the 3 water treatment plants, not necessarily the locations of residents. So, if someone could be exposed to this water if they didn't live on base at all, if they just, were a civilian teacher at one of the on-base schools, and drank the water at Hospital Point, for example. So yes, you have to figure out all of the locations where the person spent time, and it does not have to be where they resided.
Thanks, Julia. So we got a rather client-specific question from Ben, but I think it's an interesting one, and I want to pitch it to you. So Ben represents a Marine whose basic training for the Vietnam War was 28 days. That's all his DD 214 shows. But as a veteran, Ben understands that there's a report day before and a travel day when complete. So 2 additional days. How do we handle this 30-day requirement? Does he need to obtain travel orders? And in this case, this particular Marine is deceased.
Yeah, that's an interesting question. I mean, again, I would get creative. I mean, like we said before, I mean, the travel orders might work, but if he was only at Camp Lejeune for 28 days is I don't know. But I think I would like to talk to Ben as opposed to really answering this so we can get kind of the facts in order. So if he could email or call us, that would be great.
And that's a good point, Leslie.
Yeah.
Every one of our panel members is open to getting your phone calls and emails. You can reach out any of them through our direct dial line or 1-800 number, and they'll be happy to tackle your questions. Our next question comes from, give me just a moment, I apologize. So Chris asks, and you may have addressed this already, panel, but are we opening estates in the decedent state or in Onslow County, North Carolina? It's a little bit of a different variant from the previous question.
Yeah. So I can tell you what we're doing at Beasley Allen. We are going to be opening all the estates that we can in Onslow County. We are not going to be opening them in the decedent state and then having to worry about maybe having to open a second one.
But you have that choice. You have a choice.
Personal
So
preference.
yes. Mm-hmm.
So our next question comes from Jacob. Jacob says the ATSDR report references lead poisoning. Do you anticipate making any claims based upon lead exposure?
I think it totally depends on the illness. We are not just, we're being so careful and open with our illnesses, and it's something that we would have to talk to an epidemiologist about. What is the illness? Were they exposed for 30 days or more? Can we prove lead exposure, and is it connected? So yes, I would be interested in talking about that.
So Wendy has a follow-up question related to estates. She asks, okay, so we believe an estate case can be open for a foreign resident in Onslow County just for the purposes of pursuing this claim. She points out that statutes in North Carolina appear to prohibit being able to file a wrongful death claim in North Carolina if the executor is a foreign resident to North Carolina. Pretty tough question, but I want to pitch that to you. What do you guys think?
Yeah, so like I said, we have talked to some local practitioners there, and we have talked to the county clerks who would be, or the clerks working on this, and they're being instructed that that an individual can file and open an estate there because the lawsuit itself is going to be seen as an asset. And so that is one of the caveats that allows a person who was a non-resident decedent out of the state to open an estate and probate it in Onslow County if there is an asset present, and the asset is going to be the lawsuit.
Okay, thanks, Matt. I think we've got time for one more question, and it comes from William. He asked, how are you handling claimants with multiple comorbidities?
We are listing all, certainly all presumptive injuries on the claim form. If you've looked at the claim form, there are check boxes for all of the different presumptive illnesses. And then there's an other box, and you can put the other. So a lot of our claimants, have Parkinson's disease and, 3 or 4 other issues, and we list them all on the claim form, and we'll also list them all in the lawsuit.
All right,
But I would not list
Go
one
ahead.
more thing, some comorbidities such as like hypertension, diabetes, other things like that. We're not listing anything that would not possibly be a linked causally disease. Mm-hmm.
All right, thank you, Leslie. Thank you, Julia. And Thanks to all our viewers for the great questions. And I'm so sorry we couldn't get to all of them today. But again, I want to encourage you to call us. Call us with your questions. All of the attorneys on today's presentation are more than happy to help you, more than happy to run down information for you. Just reach out to them at your convenience. And for those of you who may have missed our earlier announcements, by the end of this week, you'll receive an email with a certificate of attendance and an updated presentation and video link. You can email your completed evaluation form to webinars@beasleyallen.com. Again, for those Alabama and Georgia attorneys participating by phone, please email us your name, phone number, and state bar ID number to webinars@beasleyallen.com to ensure you receive full CLE credit. For those of you practicing in other states besides Alabama and Georgia, we'll send you a certificate of attendance that you can present to your own state bar. Again, be sure to check out the events page of our website, beasleyallen.com/events, as we'll be adding more webinars throughout the coming year. Thanks to all of you for joining us today, and thank you so much for supporting our Beasley Allen webinar series. Have a good day.